You are one of the plaintiffs in this action? Am I what? Are you one of the plaintiffs in this action? That is right, I am. Please speak loudly so we can hear you. How old are you? I am 58. And where were you born? I was born in New York, Long Island. How old were you when you moved to Starr County? I was 9 years old. Where do you live now? I live on Washington and Collins Avenue. When did you commence working at oil stations in Nassau County? That was 3 years ago. And have you worked in and about oil stations since that time? With the exception of a couple of months. Has most of that time been spent working for Loeffler Company? That's right. I have been with them for all but 3 months of that time. When did you go out to this station that was involved in the explosion? Exactly 2 years ago today. And at that time you went to work or what, man? Well, Mr. Blackman was in charge. Then did there come a time when you took the station over yourself on your own? The following spring, March. In March, you took over the station to operate it? That's right. Can you tell us who owns the land there? Mr. Blackman. And does Mr. Blackman lease this land to anyone? Does what? Does Mr. Blackman lease this land to anyone? The land the station is on, I suppose, is in my lease. I imagine it is. Who owns the equipment out there at the station? The Loeffler Company. I will show you Plaintiff's Exhibit 7. Is that your signature? It is. And is that the signature of Mr. Newberry, a representative of Loeffler Company? That's right. What would you call that exhibit? That is called a customer's equipment lease. How much do you pay the Loeffler Company a year for the lease of the equipment? I don't know, as I pay anything. What does it say on the equipment lease? Oh, I know what you mean. It's one of those legal-like documents, one of those $1-a-year leases. I pay $1 on the lease. That's all. I paid it not so very long ago. And the original lease has been continued and renewed and kept in effect ever since you took over? That's right. Showing you Plaintiff's Exhibit 8. Is that your signature? That is my signature. And is the other one the signature of Mr. Newberry of the Loeffler Company? That is his signature. Is this agreement known as a reseller's contract? That is right. Do you know if this contract is in force and effect at the present time? I do. It is now in effect. Now I will show you an agreement. This is Plaintiff's Exhibit 9. Is that your signature on there? Yes. And is the other one that of Mr. Blackman? Correct. Do you know if this is a form that was prepared by the Loeffler Company? That is right. Did you purchase petroleum products only at the station? That is right. When you made your checks out to pay for the gas and oil that you purchased, tell the jury what you made the checks payable to. Loeffler Company. In other words, if you were to purchase 800 or 600 gallons of gas, you would make your check out to Loeffler Company? Loeffler Company, yes. Are the underground tanks that are in question and the other equipment of the station all owned by Loeffler? That is correct. There are signs at the station that have been put up, are there? Yes, advertising signs, yes. Who owns those signs? The company. Do you mean Loeffler Company? Yes. Any other kind of advertising? Yes, some posters. Where do you get the material from? Mail. From where? From the Home Office. I am showing you Plaintiff's Exhibit 10. Is that an ad which was sent to you from their Home Office? That came just momentarily about a month ago. What do you do with various advertising that is sent to you? I put them up, some on the outside of the building and some on the inside on the wall. Do you handle any tires at the station? I can handle tires, but I don't handle them at the station where the explosion was. I sell them at another station. Who sends you those tires? Same company, Loeffler Company. Do you handle accessories? I do. Who sent you spark plugs if you have them? Saturday afternoon, defendant, a police officer for defendant town of Amherst, received a dispatch of customer trouble involving a white male patron at the bar intoxicated. Miller responded to the call by heading to the location of the bar with his emergency lights and siren activated. Miller's vehicle collided with a vehicle driven by plaintiff's decedent as she attempted to turn into a shopping plaza in front of Miller's vehicle. Decedent died as the result of the injuries that she sustained in that collision. We conclude that the Supreme Court erred in granting that part of the defendant's motion seeking summary judgment dismissing the complaint, insofar as it seeks to impose liability on the town with respect to Miller's operation of the police vehicle. Although defendants met their initial burden on the motion, plaintiffs raised a triable issue of fact whether Miller acted with reckless disregard for the safety of others in his operation of the police vehicle. Plaintiffs submitted evidence that Miller was traveling at a speed between 62 and 72 miles per hour. Miller's conduct exceeded the posted speed limit and cannot alone constitute a predicate for liability, since it is expressly privileged under Vehicle and Traffic Law, Section 1104. The defendants acknowledged, however, that there was other vehicular traffic in the vicinity, and plaintiffs raised a triable issue of fact whether Miller was in violation of the rules and regulations of the town police department. Plaintiffs expect in the area of police vehicle operations and emergency responses, the expert opined that Miller's response and operation of the vehicle was in reckless disregard for the safety of others. We conclude, however, that the court properly granted that part of defendant's motion seeking summary judgment dismissing the complaint insofar as it seeks to impose liability on the town board on the actions of the 9/11 complaint writer and the police dispatcher. Defendants established as a matter of law that the determination of those individuals with respect to how much information to relay involved all the exercise of discretion, and thus the town may not be held liable for the consequences of their determinations. We therefore modify the order by denying defendant's motion in part and reinstating the complaint insofar as it seeks to impose liability on the town with respect to Miller's operation of the police vehicle. It is hereby ordered that the order so appealed from be, and the same hereby is, unanimously modified on the law by denying defendant's motion in part and reinstating the complaint insofar as it seeks to impose liability on the defendant, town of Amherst, with respect to damages and the like. It seems to us that Miller's operation of the police vehicle and, as modified, the order is affirmed without costs. Plaintiffs commenced this action to recover damages for injuries sustained by the plaintiff Sandra Marlowe in a motor vehicle accident. The Supreme Court erred in denying defendant's motion seeking summary judgment dismissing the complaint based on the release signed by plaintiffs. Defendant met her initial burden of establishing her entitlement in the matter of by submitting the release and the deposition testimony of plaintiffs. Acknowledging their signatures on that release, C. Fleming versus Ponzini, 24, New York 2nd, 106, 111, 299, New York Supplement 2nd, 134, 247, Northeastern Reports 2nd, 1140. Where, as here, the language of a release is clear and unambiguous, the signing of a release is a jural act, including on the portions specified. Booth versus 3669 Delaware, 92 New York 2nd, 934, 935, 680 New York Supplement 2nd, 899, 703. In opposition to the action, plaintiffs failed to raise a triable issue of fact with respect to their claim that the release is void based on fraud. See generally Merglazer versus Crystal Properties Association, 179, Appellate Division 2nd, 177, 181, 583, New York Supplement 2nd, 229. It is hereby ordered that the order so appealed from be, and the same hereby is, unanimously reversed on the law without costs. The motion is granted and the complaint is dismissed. In this case, it was determined that following a trial, however, the permit was properly revoked, both because petitioners violated conditions attached to the permit and because petitioner's business did not fall within any of the categories set forth in a major arterial district.
It's good.
See what happened to my medical insurance.